Hello and welcome to Rights and Recourse, a program that tackles issues affecting your rights and matters of legal recourse. My name is Dumile Mateza. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. The 25th African Union Summit, focusing on women empowerment and development, which was held in Johannesburg recently, has come and gone, but the summit was overshadowed by the attendance of Sudanese President Omar Hassan al-Bashir, who is wanted by the International Criminal Court for a murderous campaign which left thousands of people dead and 1.5 million displaced in Darfur. South Africa's failure to arrest and hand over the Sudanese president to the International Criminal Court has left the government with a hot potato. Not only that, al-Bashir's visit has also sharpened the debate about the ICC's credibility and impartiality, with skeptics accusing the court of only targeting African head of states. Today on Rights and Recourse, we'll look at recent developments and obligations of member countries who signed and ratified the Rome Statute. To unpack these issues, let me welcome here in the studio Ms. Angela Mudukuti, who is a lawyer and from the Southern African Litigation Center. We're also joined by Dr. Alfredo Hengari, Senior Research Fellow from the South African Institute of International Affairs. And in our Durban studio, we are joined by Mr. Barnabas Xulu, Director at Xulu Incorporated. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Good afternoon. Thank you.
First of all, Mr. Xulu, probably I hope you can hear us down there in Durban. First of all, it would seem to me at face value that, as our introduction says, probably as we go along, that the President Omar al-Bashir was indicted and implicated by the ICC by association rather than hard evidence, as the real perpetrators are the Janjaweed militia. Do you want to?
Well, I think it's a very difficult question to respond to. But first, let me start with the Janjaweed militia, because I think that will give us an idea as to when it comes to the role of President Omar al-Bashir in the genocide in Darfur. The Janjaweed militia is essentially composed of Arab men. It means essentially men on horseback with a gun. It started as a sort of a low-intensity type of conflict and massacres committed on what was traditionally African agricultural communities in Darfur. But the scale of the violence increased because there has been some clear evidence of the Janjaweed being assisted by the state. In the form of initially when they started with they were on horseback, but they started to have 4x4s, and they were also accompanied by helicopters. So these are some of the questions that really started to focus attention to the government in Khartoum. So I think the scale of the genocide, one cannot effectively ignore the role of the state.
Do you want to add to that, Angela?
Well, yes, just to say that the ICC's evidence has implicated President Bashir and connected him to the Janjaweed, offering commands and financial support for their activities. So there is a link that's been made. And also, remember, with international jurisprudence, we often look at the command responsibility doctrine, which then also involves the relevant parties who are pulling the strings, so to speak. And it's not just Bashir. I mean, his Minister of Defense has also been indicted by the ICC.
Let's get a view from Mr. Barnabas Xulu in Durban. Mr. Barnabas Xulu, you heard the evidence before the ICC.
Yes, I had the evidence. The evidence, in fact, was, in fact, the decision that was taken by the ICC,
yes,
was based on the evidence which was referred to by the Security Council, when the chamber then decided to indict President Omar al-Bashir. But that question actually is not an issue now, whether there is evidence or no evidence. I thought our focus today would be on whether South Africa carried out its obligation, and if it didn't, what then is going to be the question after that, if it didn't carry out its obligation as a member of ICC. I don't think that we can dwell on the question of what kind and the extent of the evidence at the moment, as we know how the matter has unfolded.
Okay, let's leave off for a moment. I want to come back to it later, but I just want to say Mr. Kulu has raised an issue that this case was referred to the ICC by the UN Security Council. My concern with that is there are, in the UN Security Council, there are seat members who have neither signed nor ratified the Rome Statute.
That is a valid concern, but it doesn't negate the fact that the ICC then conducted an independent investigation into Sudan and found that there was evidence of genocide.
That was the Kasisi Commission?
Yes, and found that there was evidence of genocide, war crimes, and crimes against humanity. So whether or not UN Security Council members have ratified, the point is there's evidence and there are crimes that are being committed and justice has to be done. It is a valid concern that perhaps at the UN Security Council level we see politics at play more than anything else, but the UN Security Council cannot refer a matter and then the ICC take it just because it's come from the UN Security Council. The ICC has to independently evaluate that situation and then indict people.
And then they did the investigation, they came across what you gave us earlier.
Yeah, it is true that the evidence and also the hard facts show that about 400,000 civilians were killed in Darfur. The evidence also tells us that 1.2 million, 1.5 million internally displaced persons from that region. So I think there's a clear case here for Omar al-Bashir to answer. And I think the critical question that possibly would come later in the debate is the AU position that was taken at the Extraordinary Summit in 2013, whether that to a certain degree shift the cursor to another level where African heads of states have to think as to whether they need to deliver one of their own.
One of the things I want to come to, we'll come to that, but what I want to come to, I just want us to get over this. What is the Rome Statute and what role does it play in the adherence to indictments by the ICC?
The Rome Statute is the founding treaty of the ICC, and it basically has built the framework for international criminal justice. So it details crimes against humanity, genocide and war crimes, the evidentiary standards, the rules and regulations with regard to the Assembly of States parties. So it's the backbone to the International Criminal Court and to the international criminal justice framework we have today. Mr.
Kulu, you wanted to say something there?
Yes, I want to say something that it is an independent body. It's not a body of the UN, and in this case the UN supersedes whatever is decided by the ICC. Now, the challenges that we are dealing with now are primarily caused by that, because in terms of the UN or in terms of the customary international law, the head of state enjoys immunity. And that is in terms of the international customary law. Now, the question that you should be asking ourselves is whether Omar al-Bashir enjoys that protection which is there in the rules of customary international law.
Thank you very much. Before
my view is that he does enjoy that immunity.
Let me come back to something we said when we were off air regarding the Rome Statute. What are countries who are signatories and who have ratified the Rome Statute supposed to be doing?
Before I get to that, I'd just like to contradict my learned colleague. The UN Security Council referral 1593 of President Omar Bashir removes his immunity. So there is no immunity in his case.
Well, I have a different view, with due respect, my learned friend, in the following, because there is no way the Security Council, for that matter, can delegate its powers or its authority to the ICC, because ICC is not competent to receive that power.
We'll come to. I think there's a difference of opinion here. We'll come to that. But let us go back to the Rome Statute. Yes. Earlier, before we came on air, we had how do countries domesticate the Rome Statutes?
Very simple. They integrate it into their domestic law. Usually they integrate it into their Criminal Procedure Act or their criminal code. So it becomes domestic law. So they look at the Rome Statute text and they incorporate it in such a way that it complies with domestic law regulations, as South Africa has done.
South Africa has done that, Mr. Kulu, down in the South Africa has done that by creating Act number 27, which actually is the implementation of the Rome Statute, and it's within our legislation. Do you want to comment on that?
That is correct, but where there is conflict, like it is the case now, where there is conflict, the UN Charter supersedes or has supremacy over whatever the ICC provides.
Let us get over this UN Charter thing, Dr. Hengari. The UN Charter, as we all know it, actually is a very broad principle of the UN. Now, the Rome Statute is a very specific statute that says all member states have an obligation to arrest anybody who is a fugitive to justice internationally.
Well, that is quite correct, and in the case of South Africa, where the treaty has been domesticated, even more so. But the critical issue here is the manner in which the ICC over the past few years have been contested by African heads of states, and specifically the African Union. So I think it raises a number of conundrums when it comes to the application of the right application of the statute, especially in the case of South Africa. I do think that the key turning point in my view was the case of Uhuru. That's when African heads of states said enough is enough, because there are clear suggestions that the ICC did not have sufficient evidence to prosecute Uhuru Kenyatta, and that raised a number of eyebrows in African capitals. So I think my view is that there has been a turning point. So I don't think that
we'll come back to that. I'm sorry to interrupt you. We'll come back to that when we come back from the break. If you'd like to join us today's discussion, you can please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse. Stay with us. Who will be sacrificed in the name of Bashir? No. Welcome back, and we are discussing the issue of the ICC and the President Omar al-Bashir from Sudan. With us here in the studio is Dr. Shiruma, I don't know whether I've got that right now, Shiruma Hengari and Angela Mudukuti, and down in Durban we've got Mr. Barnabas Kulu. It would seem to me, despite the fact that there are 31 African countries that have signed and ratified the Rome Statute, some have signed, some have not ratified, some have signed the Rome Statute, that the opposition to the ICC is rather self-serving. Am I right? Am I wrong? Mr. Kulu, you want to come in there?
In this case, for instance, Sudan is not a member of the ICC, so it is not bound by what the ICC decides. It is then not affected by whatever decision that the ICC takes. That is why there is now a problem with this indictment, because it is only applicable solely to those people who are members, or to states that are members. And the UN Charter excludes decisions by ICC to affect its members as such.
How difficult?
Yes, they have agreements. There's an agreement between ICC and the UN, but even that agreement does not take away the obligations of the member states in the UN to be filtered into those who are members of the ICC. So the starting point really is to look at the framework of taking from the UN Charter and all conventions there, as well as agreements arising from the Charter, before you even go to the ICC.
I would want to make, at some stage, Mr. Kulu, I wanted to make the connection between the UN Charter and the ICC and the Rome Statute so that we are at the same wavelength, because I'm trying to find the link between the Charter and the ICC and the Rome Statute. But let's go ahead. The question I wanted to ask, first of all, is how difficult does it make it for the ICC, that does not have law enforcement agencies, to make this job of prosecutorial authority work rather than relying on member states to make the arrests?
It does make it very difficult for the court, but the beauty of the court is that it works on a system of cooperation. And we are moving towards a model where we don't force people to do things, but people agree to it and then adhere to it, which I think is personally a more progressive model. But as we see now, in reality, it doesn't always play out the way you would hope it would. But ideally, states would adhere to their responsibilities, and in this case, South Africa would have arrested President Omar al-Bashir.
But why did South Africa not do its obligation, meet its obligations?
I think it's a political question. As we know, South Africa was part of the decision in 2013. Where the AU decision at an extraordinary summit, where leaders agreed that no sitting head of state must be tried by the ICC. And I think that also opened some opportunity for possibly better cooperation once the head of state, the indicted head of state is no longer in office. I think that was the thinking behind that type of position, because clearly, as I had mentioned earlier, the case of Uhuru was a turning point. Where African leaders felt that this is just not correct, because...
We'll come back to that. Mr. Kulu, I know you wanted to say something. I'll come back to that. There's a caller on the line. Noah, good afternoon and welcome to Rights Recourse.
Hello, how are you?
Fine, thanks. How are you?
Yes, I just want to contribute on Bashir. I'm phoning from Johannesburg.
Yes.
Yes. I think they should have not invited him in the first place, because this, as I see it, it's an embarrassment, because these things, it will say South African government doesn't respect the court of law in other ways. But I think the best way it was supposed to be, they should have not invited him into the South African soils.
Thank you very much. Thank you very much, Noah. Thank you. We got your gist of your question there. Mr. Kulu, Noah says, I think you can combine this with your answer you wanted to give us the last time. President Omar al-Bashir should not have been invited to South Africa in the first place.
That is not correct. He is protected as the head of state. The Geneva Convention protects him. The customary international law protects him. He is the head of states currently. He cannot be charged by foreign governments as it is. He is excluded from that criminal jurisdiction. Now, the AU, in the AU, he was participating, executing his diplomatic mission, and he enjoys the protection. The arrest of President Omar al-Bashir is basically at the behest of the Security Council. We've seen other tribunals that were established by the UN. They were effective because they were deriving the power from the Security Council, and it was more of an extension. The ICC is not the extension of the UN. Now, if you are a member state in the UN, you'll focus on the obligations that are created by the UN to you as the member. And in this case, South Africa was relying on the UN provisions or conventions which actually gives immunity.
I don't think South Africa was relying on the UN provisions.
No, absolutely not. And I have to interject again because the Geneva Conventions have nothing to do with immunity. Geneva Conventions are about war crimes. And secondly, South Africa was relying on this government gazette that they promulgated in June that supposedly gave immunity to Bashir, but that never passed through both houses of parliament, so cannot be law. If the executive could just promulgate something in the government gazette and it becomes law tomorrow, we'd be subject to all sorts of things. For something to become law in the Republic, it must go through both houses of parliament. That immunity government gazette clause did not go through this process. And even if it had, it would still be unconstitutional and invalid. And so South Africa, the legal representatives from the state didn't make any submissions about the UN Charter. Their focus of their argument was that there is immunity based on the promulgation of this government gazette.
Talking about that, now that South Africa has promulgated the Rome Statute into their own legislation, how difficult is it going to be for South Africa to change that and withdraw from the ICC? As there's been calls made that South Africa withdraw.
There is a process. Once again, it has to go through both houses of parliament, and then the executive has to sign on it, and then they have to write a letter to Ban Ki-moon indicating their intention to withdraw, and only a year after that letter has been handed in is withdrawal effective. So it's a long process. It can't happen overnight.
Let us take this call from Sipho from Johannesburg. Sipho, good afternoon and welcome to Rights Recourse. Hello, Sipho.
Hello.
Yes, Sipho, how are you?
Hello, I'm fine, thank you. How are you?
Fine, thank you. Can you ask your question?
My comment is just to add that Nkosazana Zuma made it very clear that in addition to Al-Bashir enjoying, as a head of state, immunity, diplomatic immunity, and so on, there was also, in addition, the one he enjoyed from the AU. One must also remember this is against the background that at some stage we had George Bush Jr. coming here. We had Tony Blair, that many people, including the International Human Rights Commission, had actually asked that they should be arrested. And this wasn't done. The IC didn't push this, you know. So here,
we don't want you to sidetrack us because there's no indictment against George Bush. There's no indictment against Tony Blair. Let's get that clear quickly.
Yeah, that is correct. There's no indictment against Tony Blair or George Bush Jr. So I think that argument is slightly invalid. The case of Omar al-Bashir is quite clear. And in terms of South Africa's law, South Africa had the obligation to arrest Omar al-Bashir. The decision that was taken is one that is largely political. It had to do with South Africa's own foreign policy considerations in Africa.
I want to come to the foreign policy issue when we come back. If you'd like to join us, you can call us on today's discussion on 011-714-5497 or 5498, or tweet us at Rights Recourse, or email your thoughts to rightsrecourse@sabc.co.za. Stay with us.
Culture is most definitely defined through one's individual style, be it through music, lifestyle, and fashion. Live Magazine has been in existence since 2010. It is a youth-run media channel covering a range of topics from fashion, politics.
We need, and there's a huge gap in South Africa, skilled museum personnel, such as collections manager, restorers. That is a gap.
Pattern of contact includes the 14th century Chinese world map. This is one of the oldest surviving world maps, titled Da Ming Hun Yi Tu.
Join Musam Khalifi on Afro Showbiz every Saturday at 19:30 CAT.
Welcome back, and let's now first hear what the Twitter community has to say on this issue. Snoopy says, who will be sacrificed in the name of Bashir? Tony Roberts says, no use Zuma made up his mind about everything. That's why SA is failing. And then Snoopy again. Snoopy's a tweeter. Just one Q. Who is in charge of our justice system? JZ or Muhweng? Why is the government investigating al-Bashir's escape? What questions would you like to ask our panelists? Oh, that's a question we asked them, and that's what the Twitter community is saying. Angela, you wanted to clarify something around the invitation to President al-Bashir.
Absolutely. The first caller raised it, and I think that's a very fair point, because we saw that in 2009 for President Jacob Zuma's inauguration, Bashir was invited. But the DG of DIRCO made it clear that if he comes, he will be arrested. Bashir didn't come. Same thing in 2010 with the World Cup. He was invited, but it was also made explicitly clear that should he come, he will be arrested. So which is why this debacle that we have now is highly irregular when we look at South Africa's behavior in the past with Bashir.
Mr. Kulu, he was invited for the inauguration of the president, was invited for the World Cup. Why did he not come? Why did he not force and come? Because he was invited by South Africa.
Well, firstly, I don't hold any brief from President Omar al-Bashir.
We respect that.
My comment is just an opinion based on the international law practice of what is supposed to happen. I will know the facts really related to that specific incident or those two incidents. All that I'm saying is if I was South Africa, because if they've effected this arrest, the Sudan government may have easily referred them to the international criminal, the international court of justice for the breach of what is there in the United Charter and the rules dealing with the customary international law.
There is a call on the line. Mr. Tulu, thank you very much. I'll come back to you. My apology for interrupting you. There is a call on the line, but I first want to understand this. What role did the xenophobia incident in South Africa a couple of months ago had to do with this decision?
Well, I think one can only speculate that it might have played a minor role in terms of the overall decision taken, because it's important to also know that South Africa did take a bit of a beating in terms of its image on the African continent. There has been some, when you travel to some African capitals, people will tell you that South Africa is not African enough. You have all sorts of adjectives used to describe South Africa. And that has to do with some of the issues that make South Africa also South Africa, which is, for example, the issues of rule of law, a democracy that is functioning much better than many African countries. So for South Africa to think about arresting Omar al-Bashir in that climate where South Africa is also has expectations of itself in terms of a role on the African continent, to see itself as a protector of African interests. And I think the position that was taken by African leaders when it comes to the ICC is one that seeks to affirm Africa vis-a-vis, what is now seen as a Western, a pro-Western institution.
Dr. Hangari, let's take this call from the Eastern Cape. Nono, good afternoon and welcome to Rights and Recourse.
Good afternoon, Dr. Dumile Mateza. Listen, sir, you know what, the only interest that I'm having with your panel is, what interest is the South African media do they have an interest of Africa, or do they have a European or an American interest? That's it. Because to me, you take your big vote.
Thank you. We got your question. Your question is, what interest does the media have? And I think the media has a great deal of interest in terms of the adherence to the rule of law.
Absolutely, because South Africa domesticated the Rome Statute and has taken it upon itself to adhere to these obligations. And so this is a rule of law question, which is why the court ruled in our favor that they should have arrested Bashir, because the law on this is clear. So South Africa has obligations. So in a sense, this is less about Bashir, but more about South Africa's obligations as a signatory to the Rome Statute and as a nation that's domesticated the Rome Statute of the ICC.
We've got a lawyer down in Durban. Mr. Tulu, the court ruled on Saturday that ruled on Friday. Was it Saturday or Friday? Sunday, that the President Omar al-Bashir should not be allowed to leave South Africa. And it would seem to me we do not adhere to a fundamental issue of the rule of law. What's your view?
Well, on the face of it, it looks like that. South African government needs to explain I've just pointed out what I'm of the view strongly that there was no way this arrest was going to be lawful, because the resolution by the
AU
Security Council to refer this matter to ICC was the resolution 1593 was ultra vires. There is no way in which they could have waived the immunity of the head of state. So on the face of it, the order of the court was supposed to be respected by the South African government, but they have a chance now to explain why they have not complied.
I think I want to go back to something you raised. My apologies. I want to go back to something you made around the issue of the Security Council. I also made that announcement. I didn't get your view on that. And that is, why would the Security Council refer a matter to the ICC when there are members sitting at the Security Council who have not signed, neither ratified the Rome Statute?
That is what has placed this whole case into this dilemma. Possibly politics has had a role to play in that regard, but because ICC is not a body of the United Nations, so it can't assume any obligations that are created to member states in the UN Charter. It can't assume. It doesn't have competence.
I think let me come back to Angela on that. Let me come back to Angela. Angela, you said if South Africa were to withdraw, they'll have to write a letter to the Secretary General of the UN. Now, that brings the connection between the UN and the court.
Yes, I have to once again disagree with my learned colleague. There is a connection with the two. There are three ways in which something can come before the ICC. A United Nations Security Council referral, as per the Rome Statute, a self-referral, where a nation independently subjects itself to the jurisdiction of the court, or the prosecutor can exercise her jurisdiction in a country that has signed and ratified the Rome Statute. So what we see with Bashir in Sudan is that United Nations Security Council referral, which is legitimized because it's stipulated as such in the Rome Statute.
I want to come back to something you mentioned just now, where nations can subject themselves to the jurisdiction of the court. We saw that happening with Cote d'Ivoire with respect to President Gbagbo.
Yes, Cote d'Ivoire, Uganda, Mali. There's several examples. Central African Republic, all self-referrals.
Earlier we spoke about, I want to come back to this issue of the South Africa's foreign policy. We spoke about the foreign policy, despite the declaration by President Mandela that South Africa's foreign policy will be guided by a human rights ethos, and this was evident during his administration. Has something changed in the South African foreign policy?
Well, it's very difficult to say that something has changed. But at the time when Nelson Mandela was talking about issues of human rights, South Africa was not yet an active player on the African continent. So the terrain in Africa and South Africa's initiative started to encounter problems in Africa when it comes to some of the values that are quite central in South Africa's foreign policy. So the critical question became also, how do we engage Africa when we put issues of human rights in front? We might run into problems. So maybe we have to rethink the engagement strategies when it comes to some of these countries, because you cannot talk peace in Sudan, for example, and then you elevate issues of human rights in front of Omar al-Bashir. I don't think that he's likely to listen to you. So South Africa's agency in Africa was constrained by the realities on the ground. So I don't think that South Africa has in any way devalued issues of human rights in Africa. I don't think so. I think it's a question of the diplomatic engagements of the country, where the country started to encounter serious problems.
Well, we saw actually at that time when President Mandela was the president of South Africa, his outgoing criticism of Nigeria at the Commonwealth summit, where he actually led to Nigeria being suspended, and Nigeria refused to send their soccer team to come and play in the African Nations Cup in 1996.
Yeah, that's a very good example where possibly the first encounter South Africa had when it comes to issues of human rights in Africa. And I think after that, there was a clear revision of South Africa's engagement strategy, because Nigeria did not take South Africa's interference in Nigeria's domestic affairs kindly. And there has been a clear shift in South Africa's foreign policy when it comes to issues of human rights, not to diminish them, but to sort of let's try and see how we can domesticate issues of human rights at the AU level, instead of South Africa being the country that speaks on issues of human rights, risking the eye of other African countries.
I get a sense here, Angela, that South Africa finds itself between a rock and a hard place, with its constitutional institutions and solidarity with its neighbors that frown upon and perceive the ICC as Western interference in their domestic affairs or in their sovereignty.
Some people have said that, but I think I would have to disagree, because obviously if you look at the AU Constitutive Act, it talks about accountability, justice, and bringing an end to impunity. So how does this debacle correlate with South Africa's so-called obligations at the AU level? I think there is a lot of inconsistency. I think it's a game of politics, unfortunately. And I think the law and the greater good is clear. Justice and accountability is necessary, and South Africa had a chance to do that.
Mr. Lulu, down in Durban, quickly, I don't know whether you want to respond to this issue of the change in this foreign policy of South Africa.
I won't have much comment on that. My take is just on the observing the law as it stands. The immunity is a reality. There was no way, this arrest could have been legal by the South African government. On the change of policy dealing with human rights and the African continent, the organizations like the South African Litigation Center could not have assumed the obligations of the South African government as they were trying to do in law. I don't know on what basis they've assumed those obligations, because there is no way, even in the ICC, ICC as the International Criminal Court does not extend its powers to organizations like the South African Litigation Center.
I think
so that remains.
I don't want this to be a discussion between Mr. Lulu and the Southern African Litigation Center, but I want to go back to the Constitution, the South African Constitution. The Rome Statute aside, subsection 5 of the Constitution goes further to say, I think I quoted one other section of the Constitution, section 165, subsection 2. And subsection 5 says, goes further to say that an order or decision of the court binds all persons to whom and organs of state to which it applies. Is government in contempt of court here?
Government could potentially be in contempt of court. We're waiting for the court to issue the reasons for its order, and we're also waiting for an affidavit that the state is due to submit next week that explains exactly how President Omar al-Bashir escaped and who's responsible for that. So pending that, we can't make a decision or a declaration as to whether there's contempt of court, but we need to wait for those documents. And I must seize the opportunity to explain the Southern Africa Litigation Centre's role in all of this. The Constitution of South Africa gives human rights organizations locus standi to bring cases that are in the public interest before the court. And that's exactly what we did. Justice and accountability are in the public interest.
Mr. Lulu, I think you heard that comment there, but I want to add to that, in that probably it is in the interest of civil society to interpret their own constitution. And when you interpret your own constitution and your law, you have a right to bring a case to court against anybody.
That is correct, but have they observed the existence of this head of state immunity?
I don't think probably one of the other things that has not been done is to explain the African Union's own immunity details. I think you spoke about they stand for humanity and justice and all of that's what they say in their founding documents, but we haven't seen that, have we?
Yes, and as I indicated before, the law is very clear, which is why the court found in our favor that immunity is not applicable in this situation. So I think we need to one, look at the judgment, and two, understand that sort of directly attacking the Southern Africa Litigation Center doesn't further the cause, anybody's cause. We need to look at the law and look at the judgment. So immunity does not apply in this situation, which is why the court found in our favor.
Dr. Heringa.
Was not going to be applicable.
No, go ahead. Go ahead, Ms. Kulu. Go ahead.
The immunity was not going to be applicable only if it is waived by the Sudanese government. In this case, it did not waive immunity to protect Omar al-Bashir and other members of the cabinet, because they are protected. The only stage where this could have been waived is when the state itself consent to that. And in this case, it has not consented. In as much as the UN could not have waived it, the UN and the Security Council could not have waived the immunity which protects Omar al-Bashir.
Let's come back to something else, Dr. Heringa. Dr. Heringa, there has been a general call from, amongst others, no less a person than the President of Zimbabwe and Chairman of the AU, that African countries should withdraw and block from the ICC. Could this be the only solution?
I don't think that it's the only solution. And that position is not new. In 2013, when President Uhuru Kenyatta
and his deputy, William
Ruto were indicted by the ICC, a number of African countries were pushing for withdrawal. And that's why that extraordinary summit was called in October. It was to discuss the ICC, Africa's position on the ICC in particular. And it's important to mention here that South Africa was one of the countries that insisted that we should not withdraw from the ICC in the absence of other solid legal instruments on the African continent to deal with issues of impunity. So I think today the question of withdrawal, in my view, is no longer one that is urgent, because the question that was really the turning point, as I had mentioned earlier, was Uhuru Kenyatta, because prior to that there were no calls on the part of African countries to withdraw from the ICC, because the issue of Omar al-Bashir clearly divides the African continent. I do believe sincerely that there are African leaders who believe that President Omar al-Bashir has a case to answer in Darfur. So Uhuru was a turning point, because we are dealing with a democracy here that is quite respectable, and also the overzealousness of Ocampo at the time.
I wanted to come to that. I'll come to the overzealousness of Moreno Ocampo. If you'd like to join us, you can please call us on 011-714-5497 or 5498, or tweet us at Rights Recourse, and email us on rightsrecourse@sabc.co.za. After the break, AU spokesperson shed light on the stance of the AU on President Omar al-Bashir, so that we don't put words in their mouths.
Sparks fly over Verwoerd. Let's now have a look at this. Now, Verwoerd, the comment yesterday in Njanji, Mr. Sparks lived up to his name and caused quite a few sparks.
It was quite shocking for me to hear him compare H.F. Verwoerd to Helen Zille in terms of her orator skills.
Mugabe to compensate white farmers for land grab.
I don't know if I'm justified to call it truth and reconciliation Mugabe style.
Watch Media Monitor with me, Alicia Jali, Sundays at 9 a.m. only on the SABC News Channel.
Welcome back. AU spokesperson Jacob Eno Eburn shed light on the stance of the AU on President Omar al-Bashir.
The last couple of summits of the African Union heads of states have had this issue as part of the agenda, just talking about Africa's relations with the ICC and to redefine it. And that's why enormous pressure was put for President Kenyatta's trial to be dropped, which has been dropped. And so we're working now on other cases, the Deputy President of Kenya, as well as that of President al-Bashir. And for us, and it's not to communicate that the African Union supports impunity. In fact, if you look at the Constitutive Act, we are moving forward to having an African court where we are going to have such issues. I don't know if those detractors who are talking about the AU and supposed promulgation of impunity are looking at the trial of Issa Nabrain that's currently taking place in Senegal. okay? Just to tell the public and the rest of the world that the AU doesn't promote impunity, but then we are working to ensure that our continent really achieves some of its goals of integration, development, and for that matter, the theme for this year is women's empowerment and development towards Agenda 2063, and would really like to focus on this.
Well, you heard there even Ido talking about Hassan Harbour. Hassan Harbour was the president of Chad who was being tried in Senegal. That's after many, many years. Well, let's take this call from, before we comment on what he said, let's take this call from Fernando in Durban. Fernando, good afternoon and welcome to Rights Recourse.
Good day.
How are you, sir? What is your question?
Good afternoon.
Yes,
I just want to ask the lawyer a question from Durban, that if an order was issued by a high court that he is not to leave the country, and if a full bench of judges have found him to be arrested, how can the lawyer then say it's not valid? And if that is the case, that if our full bench of judges and the high court judge is wrong, then we are really, really in trouble in this country.
Thank you, Fernando. Mr. Kulu, you heard that question from Fernando. I think it was directed at you.
Yes, I've heard the question. The court order remains to be answered. They still have to give explanation how did he get out of the country. Now, I've said to it, on the face of it, it will seem as if the South African government have committed an attempt, a contempt of the court order. But we don't know what is their explanation, and I think we should be respecting the opportunity which is given now to the South African government to provide its explanation.
Well, I think Mr. Kulu is right. We cannot preempt the fact that the South African government is in contempt of court until the court says so, until probably you guys bring your application to the court. You wanted to say something around that?
I wanted to actually discuss this idea of withdrawal.
The idea of withdrawal from the ICC.
And just to say that it's potentially the worst thing the African continent would do, because if we look at the SADC tribunal, it's been disbanded, and if it comes into existence again, it will only be a court that will hear interstate disputes, removing that individual access. So what will individual victims do then? We look at this African court that the AU representative has just spoken about. That African court currently doesn't have criminal jurisdiction. And the protocol that will give it criminal jurisdiction includes immunity for heads of state and senior government officials. Now, the definition of senior government officials is very broad. Immunity for heads of state, when people stay in power for 30 or 40 years, evidence disappears, witnesses die. How does this make sense for a continent that's trying to encourage justice and accountability?
Well, yes, I wanted to come to exactly that point. That is, this African Court for Human and People's Rights was established in 1998, but to date, we have not seen no cases before this court. And 1998 is a long time, nearly 10 years ago.
Oh, it's busy with cases, but not criminal cases. So cases which then result in damages, like civil award of damages.
Just want to explain something else here for our viewers, and that Angela mentioned of the SADC tribunal. The SADC tribunal had the case of the farmers from Zimbabwe, and it made findings, and those findings were just ignored. How can we then expect an African court to... I'm not saying an African court won't be able to solve issues.
Well, I think it's... as Angela rightly pointed out, there is in Africa, there has been for a very long time a culture of a state-centric approach to dealing with human rights issues, and the ICC somehow covered that gap quite well, and that's why Africa's withdrawal from the ICC will be should be seen as an insult to ordinary Africans who at times suffer at the hands of unaccountable regimes. And I think it also goes against some of the commitments that Africa or the AU has made in terms of its own act, where it talks about issues of non-indifference when it comes to large-scale abuses of human rights. So I think there is at times a clear contradiction between the commitment that African leaders have made when it comes to civilians, and also the commitments that they have towards each other, which is the state, the very state-centric aspect that they at times try to promote.
Angela, what concerned me, I've got nothing against women, was there are very real issues facing this continent of Africa. We've seen what is happening in North Africa, in Libya, in Tunisia, and all of that part of the world, and also in Nigeria. We've seen thousands of Africans drowning in the Mediterranean Sea. We've seen a whole lot of these things happening, and Africa is busy talking about women development when these cases are right in front of them.
I think it was fair that the summit was themed accordingly. I think the AU focuses on certain issues at certain times, and it's not to say that just because the summit had a particular title that they didn't discuss other things. So I think, broadly speaking, these issues are being canvassed.
Mr. Kulu, do you want to say something around that?
Yeah, look.
Probably around the court, around the African Court for Human and People's Rights.
Yes. Well, look, AU is a regional, or is a regional arrangement of the United Nations. She was correct, Angela was correct when she said, then it will inherit all that is there provided in the UN. So which means the revision or the removal of this protection which exists now can only be dealt with by the UN at its level in its assembly to remove this immunity, because the AU cannot, like all its member states are members of the UN, they cannot overrule the supremacy of the UN provision. So the court that will be established, or the established court in Africa, will have to observe those rules and the principles which are well founded.
I want to go back to that, but I want to take this call from Bongani in KwaZulu-Natal. Bongani, good afternoon and welcome to Rights and Recourse.
Good afternoon and to your guest. Thank you.
What is your question?
No, it's not a question, actually. I just want to add something on this issue.
Yes.
It's not a question. I mean, firstly, I would like to thank the guest. At least now you have come to a conclusion that let us not judge the government in terms of action taken till they explain their position. Yes. But the first important thing that I want to mention is that I'm behind. I'll recommend that AU withdraw its members from the ICC, because we had so many cases of like Iraq, to mention one, where these big countries like America and British, and those countries are part without like a UN directive. So with that, and then all those people, they've never been brought to ICC. We've never seen that. Most you see is African countries, and that are also always called it up to this court.
Thank you very much, Bongani. Thank you, Bongani. We've heard your question to Bongani talking about withdrawal, but I want to go back to something very quickly that Mr. Kulu mentioned, and that is the immunity to the head of state cannot be removed by the court. But I think if the Security Council, a high-ranking body of the UN, refers a case to this ICC, that means that immunity has been withdrawn.
Absolutely. It's that simple as you have explained it. Yes.
Quickly, we are running out of time, but I wanted to ask one.
Can I clarify
yes,
this for the last time? It is not, because ICC is not a body of the UN, so it is not competent to receive the authority from UN.
It would seem to me we'll argue about that point, because if we argue that point throughout this program, what then, this whole issue, what does it make of South Africa's stature internationally?
Well, there are two issues here. One of them is South Africa did take a bit of flack in terms of its own commitment to rule of law at home. Certainly there has been some damage there because government ignored its own code. But at the same time, there is an explanation for that, which is largely political, as I had mentioned. South Africa is also worried about how it's seen, perceived by its own African peers. So to arrest a sitting head of state when there is a position, even if it's not legal, even if it doesn't commit South Africa legally at home, there is an African position that has a certain, there is political.
I wanted to give the final word to Angela. I'm sorry to be interrupting you.
I think South Africa's reputation has been significantly damaged by this event, because we always talk about South Africa as a constitutional democracy built on respect for human rights and dignity and accountability and justice. And given the history of this country and the legacy of apartheid, it's very important for South Africa to maintain that respect for justice and accountability.
Well, it's surely clear that we are not going to solve the problems around this issue here in the studio and this program. It's been an hour long that has been going on, but we're hoping that we will see what the solution is going to be from the African Court, which I thought could be complementary to the ICC. This has been Rights Recourse. This program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.